The Colorado Supreme Court declared yesterday that Donald Trump, who's a former president and the key Republican candidate, is ineligible to participate in the state's Republican presidential primary under the rarely invoked insurrection clause, specifically outlined in Section 3 of the 14th Amendment to the United States Constitution. Section 3 prohibits individuals who have taken an oath to uphold the Constitution from holding office if they have subsequently engaged in insurrection or rebellion against it. Trump's lawyers argue that the events of January 6 did not constitute a serious enough insurrection, and any statements made by Trump during that time were protected under free speech. Hello and welcome back to New Wave Global. I've been away a bit, working and traveling. Anyway, I am here to talk about a really important matter. In fact, something that will have implications for US politics and its trajectory in the coming year. In a groundbreaking decision with potential implications for the 2024 election, the Colorado Supreme Court declared yesterday that Donald Trump, who's a former president and the key Republican candidate, is ineligible to participate in the state's Republican presidential primary. This historic ruling marks the first instance of a presidential candidate being disqualified for election under the rarely invoked insurrection clause, specifically outlined in Section 3 of the 14th Amendment to the United States Constitution. This insurrection clause, ratified in 1868 as part of the post-Civil War amendments, was initially designed to prevent former Confederate officials from reclaiming power in government. Section 3 prohibits individuals who have taken an oath to uphold the Constitution from holding office if they have subsequently engaged in insurrection or rebellion against it. Legal scholars increasingly argue that Trump's involvement in attempting to overturn the 2020 presidential election and impeding the peaceful transfer of power to Joe Biden aligns with the intent of this clause that covers insurrection. Now, that's the legal position. What do the experts say? I mean, Ron Fine, the legal director for Free Speech for People, emphasizes that the framers of Section 3 anticipated the dangers of allowing an oath-taking insurrectionist to return to power. Fine contends that such individuals could pose a threat by repeating or exacerbating their insurrectionist actions. The Colorado Supreme Court's decision emerged from a case brought forward by a group of Colorado voters, supported by the organization Citizens for Responsibility and Ethics in Washington, D.C. Their argument centered on Trump's alleged disqualification due to his involvement in the January 6th attack on the U.S. Capitol. The court's ruling overturned a previous decision by a district court judge who acknowledged Trump's role in inciting insurrection but questioned whether the insurrection clause was intended to cover the presidency. The insurrection clause outlined in the 14th Amendment has rarely been applied, and this case represents its first high-profile use since 1919. In that instance, Congress refused to seat a socialist in Congress, obviously quite the opposite, asserting that he provided aid and comfort to country's enemies during the World War I. In 2022, a New Mexico judge utilized the clause to bar a rural county commissioner involved in the January 6 Capitol breach from holding office. As of now, the Colorado ruling specifically impacts the state's Republican primary scheduled for March 5, ensuring that Trump may face difficulties on the ballot for that particular vote. However, the decision could extend its influence to Trump's standing on the general election ballot on November 5. Well, that's what many people say, but I personally think it will not really impact his base and his support base, which is pretty wide and formidable because they don't really care about what happened on Jan 6. In fact, they cheer on that incident. Additionally, the ruling may have ramifications for similar cases in other states, notably Minnesota and Michigan, where Supreme Courts are considering similar arguments in different trials. While Trump has not really directly addressed, his campaign sent out a fundraising email saying that this verdict was a tyrannical ruling, quote unquote. Trump's legal team is preparing to appeal any disqualification immediately to the US Supreme Court, asserting that the language of the 14th Amendment does not apply to the presidency. Trump's lawyers argue that the events of January 6 did not constitute a serious enough insurrection, and any statements made by Trump during that time were protected under free speech. They contend that the courts lack the authority to remove Trump from the ballot. Now, that's the other view, of course. Well, I mean, I think this is going to be a very interesting case going forward, and certainly has serious implications for President Trump in case he does not get relief that he expects and many expect from the US Supreme Court. Now, the Supreme Court of the US, as we know, and as perhaps most of you know, is already tilted towards the conservative side. So, I mean, I was talking to some people yesterday and today, and they were of the view that perhaps he might get relief and this might be overturned. Well, regardless of whatever happens, the rule of law must take its course. And if, in case, as Trump's campaign argues, that this is an affront to democracy, etc., well, then let's see what the Supreme Court of the US says. But for now, I think many dozens of cases and charges against former President Trump will start yielding results as the United States move towards elections. And let's hope that this is resolved not in a polarized, violent manner, but through a legally sort of valid and politically legitimate manner. With that, I'll end my podcast today, and I'll be back again tomorrow. So stay tuned for more updates, but please do subscribe to our channel and do like this video if you like it, and give us ideas on what to cover and what not to cover. Thank you.